Welcome back. This is Susheta Sengupta Roy from Swami Vivekananda Institute of Modern Science, Department of Media Science. Today, we'll be covering up another small act under the media laws, the Working Journalist Fixation of Wages Act, which was prepared in 1958. Now, when we talk about the working journalists, so obviously media is incomplete without the journalists. So when we talk about the journalists, it is obvious that there are certain rules and regulations and law which will be basically guiding force or maybe a support for the journalist. So the Working Journalist Fixation of Wages Act of 1958 is one of those. So now let's get to the details of the act. Now, what does the Working Journalist Fixation of Wages Act of 1958 say? Like the first press commission found that emoluments received by journalists were on the whole unsatisfactory. It recognized the necessity of fixing a minimum wage to be paid to them. Journalist has to be paid according to their competencies and as to their work. So there has to be a minimum wage which is to be decided. The provisions applicable to workmen under the Industrial Disputes Act of 1947 shall apply the working journalist. So an ordinance entitled the Working Journalist Fixation of Rates Wages Ordinance were basically promulgated on 14th of June 1958. This ordinance was later replaced by the Act of the Parliament. The Act has been passed to regulate certain conditions of service of the working journalist and other persons employed in the newspaper establishment. So everybody related to the news agency. So under section 3 of the Working Journalist Fixation of Wages Act of 1958, it says that the owner of the newspaper can retrench an editor with 6 months notice. So any other journalist with 3 months notice. This is the, so if the owner has to retrench the editor, he needs minimum 6 months of notice, or any other journalist if they need at least a 3 months notice. So this is according to the section 25F of the Industrial Dispute Act of 1947. Now section 4 of the same act says, for the purpose of enabling the central government to fix rates of wages in respect of working journalists in the light of the judgment of the Supreme Court dated 19th day of March 1958 related to the wage board decision, and under all relevant circumstances the central government shall by notification constitute a committee. So without a committee, the central government will not be able to operate as far the journalists are concerned. So the committee which we were talking about, the committee will consist of what? A, the officer of the Ministry of Law, not below the rank of Joint Secretary. 2, like B, 3% nominated from the Ministry of Home Affairs, Labour and Employment. C, a chartered accountant. So committee may call upon newspaper establishments, working journalists and other persons interested in the wage board decisions. So every representation should be in writing and within 30 days as may be specified in the notice. So the representation must specify the grounds for modification of the central government and also specify the date from which the rate of wages should take effect. So under section 5 of the Working Journalist Act says that the working journalist who has been in continuous service for at least 3 years, remember 3 years in a newspaper establishment, are entitled for gratuity on their retirement or in the case of their death. So the basic provision of a government officer will be, this will be, that will be enjoyed by a working journalist who is at least working for 3 years in the newspaper establishment. So the employer of the establishment should pay an amount equivalent to 15 days average pay for every completed year of service, or part in excess of 6 months. So in case of death of the nominee of the working journalist is entitled of the gratuity. So in case something happens to the in case of death, in that case, so that the extra amount will be enjoyed by the nominee. So now under section 6 of the Working Journalist Act, it says that no working journalist shall be required to work for more than 144 hours. Remember, 144 hours during any period of 4 consecutive weeks, exclusive of their time of meals. Every working journalist shall be allowed during any period of 7 consecutive days rest for the period of not less than 24 hours, inclusive of the period between 10 and 6. So their working hours are absolutely fixed. It cannot be extended to any inhuman amount of time. Now, section 7 of the Working Journalist Act says that every working journalist shall be entitled to earn leave and on the full wages, and not less than 1/11th of the period spent on the duty, and leave on medical certificate, and 1 hour of the wage, or for not less than 1/18th of the period of service. So in addition, the working journalist is also entitled to casual leave. Now, Section 8 provides for the fixation of revision of rates of wages. The government, like the central government, may fix rates of wages with respect to working journalists, revise from time to time such intervals and rates of wages fixed under the section. So, Section 9 of the Working Journalist Act says a wage board shall be constituted of the central government for fixing and revising rates of wages of working journalists by notification in the official gazette. So, the wage board shall consist of what? Now, the wage board has to have some people who will be taking care of the interest of the interest of the journalists. So, the 2 representatives are newspaper employee, 2 representatives from the working journalist, 3 independent persons, one of whom shall be person who he or she has been judge of the High Court or Supreme Court, somebody of that. Now, Section 10 and 11 is the procedure and recommendation of the wage board. Now, the board has the power to regulate its own procedure. So, the board consisting of the people from the newspaper, from the working journalist, as well as some independent people who were of the justice type, the level of justice. Now, the representation shall state the rate of wages which is in opinion would be reasonable. He must consider the capacity of the employer or any other circumstances before making the recommendation. So the board may exercise all or any power which is the industrial tribunal exercises. So the board will have any power which is like as act per the industrial tribunal. Now, the Working Journalists Act section 12 says empowers the central government to enforce the recommendation of the wage board. So after receipt of the recommendation of the board, the central government may, as it think fit, like the central government will take a stand, like make orders for its implication, make modifications in the recommendation, refer the recommendation or any part thereof to the board. So the central government, before making such modifications, shall cause notice to be what? Given all persons likely to be affected. Now, every order made by the central government shall be published in the official gazette and also specify the date from which the order shall come into operation. Now, Section 13 of the Working Journalists Act says that the wage board shall be constituted by the central government by fixing or revising rates of wages in respect of non-journalist newspaper employees. So it shall consist of what? 2 representatives of the newspaper employee, 2 from non-journalist newspaper employees, and 3 independent person as it was before. So it was like from the High Court or the Supreme Court. So anyone from the courts. Now, what are the provisions of the following act shall apply on newspaper establishment employing 20 or more persons? The Industrial Employment Standing Order Act of 1946 and Employers Provident Fund Act of 1952. So these 2 are accompanying acts of the working journalists. Now, if any employer contravenes any of the provisions of these acts, he shall be punishable with a fine which may extend to ₹200. If the offence is committed committed the second time, the fine may extend to 500. Now, if the same thing, the same same problem or the same offence is being done twice. So where any amount is due under this act to the working journalist from the employer, the working journalist himself or any other person authorized in writing on his behalf, or in the case of death of the working journalist, any member of the family may, without prejudice or to any other mode of recovery, so make an application to the state government for the recovery of the money due to him. So, and the state government, it shall also issue certificate for the amount of collector. The collection shall proceed to recover the amount in the same manner. Now, when we talk about the working journalist, so it is obvious that there are some rules and regulations where it will protect the journalist, as well as even if the journalists go wrong, even they will be punished with a fine. So stringent rules, law, again, as I said in the first class itself, that the law is just application of common sense. So every person has to be guarded with rules or guided with rules so that they don't go wrong. Now, this is a very small act. I think it is clear as if the small parts of the committees as well as the punishments concerned. So thank you for now, and I'll be back again with another act of law.